Good morning, everybody. Thank you all for joining us. I'm going to go ahead and get us started on our Zoom housekeeping tips while the rest of folks make it in here from the waiting room. As always, your Zoom toolbar is at the bottom of your screen, probably depending on the kind of device that you use. And we do ask as a starting point that everybody stay muted during the Q&A unless you want to unmute yourself to ask a question. Your audio button is where you can mute or unmute yourself, and the video button is also next to it, and you can be on video or off as you prefer. Excuse me. I will start by saying that we don't have a ton of submitted questions to answer today. So we're going to cover a couple of general topics first and then dive into the handful of questions that we do have. So if you were thinking about maybe submitting a question for this week, you can feel free to do that in the chat. Your chat button or whatever might be flashing because I just put a message into the chat. That's the best way to submit questions for the Q&A today. It also tells you how to access our YouTube channel to look at videos for previous YouTubes or Q&As. And it also tells you how to submit questions if you think of one in the middle of the week and you would like us to cover it at the following week's Q&A. The chat is for asking questions or requesting clarification only, not for other stuff like, I don't know, arguing about things like people do on the CAI message boards. I don't think we have too big of a problem with that here. As we remind you every week, we are here to give general legal information, not legal advice. So if you find yourself asking a really, really detailed question or sending us excerpts of your governing documents, your question is probably too specific for this forum. We might be able to still sort of touch on the subject generally, but we're not here to and cannot give legal advice in this forum. So also, if somebody sends you one of our Q&As or a blog article or whatever and tries to tell you that you have to do things a certain way or you can't do something because of something that we said here, you can just ignore that, or even better, ask your association attorney to clarify what your best option is in that scenario. But this is not legal advice here. We are canceling the Q&A next week. We're going to be moving offices next week. We're moving a whole half a mile from our current building to a building that we're actually very excited to be moving to. So we are not going to have the Q&A next week, but we will be back here the following week, which I think is the 13th. So we'll see you guys then, but not next week. I think, oh no, CA Day is coming up on October 18th, and Katie is going to be presenting again this year. She is going to be co-presenting, I think, with Michelle Weaver. Is that right?
Yeah.
About meetings and how to comply with the upcoming changes to all of our meeting statutes, which we'll talk about a little bit today too. But we hope that many of you guys will attend CA Day. We'll be there. Come say hi to us at the booth and listen to Katie talk in her presentation. And finally, you might not realize this. We were just talking a couple minutes ago about how it's almost August. We had to change our little bullet point from the changes to WUCIOA that take effect this year will take effect on July 27th and change that to that they took effect on July 27th, because here we are at the end of the month. So to the extent that your community is already governed by WUCIOA, any of the changes that were made to WUCIOA that take effect this year are now in effect for those communities. This is not relevant for communities that are not currently governed by WUCIOA. So I think without further ado, that's all the announcements and the housekeeping. We're going to start with a couple of short primers that we think, are just the kinds of things that bear repeating or covering now and then. And I'm going to start with a really short one on governing document terminology. And we hear people kind of mix up and mash up the titles for different types of governing documents a lot. And it is important to understand that they are all different and they're not interchangeable, and that there is sort of a hierarchy of authority. So in the scheme of things, the documents that are usually recorded first are the survey map and plans and the declaration, or the covenant conditions, restrictions, CC&Rs, there's different terminology for those. Recorded documents typically carry the most weight and typically control over conflicting provisions in non-recorded documents. So if your declaration, for example, says that homeowners are allowed to keep domesticated pets of any kind, and that's it, you can't later adopt a rule that says you're banning pets from the community, because that rule is trumped by the authority of the fact that pets are allowed under the recorded declaration. So your declaration slash CCNRs is kind of like the big kahuna in terms of the governing document that has typically the most authority to control over the others. Another document that can be recorded or filed early is the Articles of Incorporation. And while most often they're pretty bare bones and don't say a whole lot about governance or use, occasionally we do see things put into the Articles of Incorporation that are relevant to governance in your community. And so that's a document that you need to be aware of, and that your attorney, for example, should look at when answering a governance related question, just in case there's something there that we wouldn't expect. Bylaws are, I would say, usually not recorded, although we do run into some that are. And bylaws are the way that this is supposed to work is that your declaration is supposed to talk about the property, the rights and responsibilities of the owners and the association, and the uses to which the property can be put. Where the bylaws are supposed to talk about things like governance, procedure, and how people in the community interact, basically. So that's where you're going to find things like how many board members you have, what's your quorum for an association meeting, how often do you have to have an association meeting, things like that. However, we do sometimes find that people also try to sneak things, or not even sneak, that implies intention. People will accidentally sometimes put something into the bylaws that don't belong there. We've seen rental caps in the bylaws. We've seen all kinds of use restrictions or other things inserted into the bylaws that, number one, don't belong there, but that, number two, are sometimes unenforceable unless they are in the recorded declaration or an amendment to the declaration. So if your declaration does not have a rental cap and you want to impose a rental cap within your community, the only way to do that is to adopt an amendment to your declaration via a vote of the ownership, and then to record that amendment. You can't amend your bylaws by a vote of the board to do the same thing and have it be effective or enforceable. That's the other thing about the bylaws, is that they are, like I said, supposed to be dealing primarily with procedural issues. Often they can be amended by a vote of the board alone. They do not always require that you have a vote of the ownership to amend the bylaws. And you would know that or figure that out for your community by looking at the document itself, which should tell you how it can be amended. Or sometimes you have to look to the declaration, which can tell you how the bylaws can be amended. The rest of your governing documents are a variety of things like your rules and regulations, your collections policy, things like that. Up until WUCIOA was enacted, those documents could all be adopted by a vote of the board without any input from the ownership. If you are a WUCIOA community, and again, on January 1st, 2028, we're all going to be WUCIOA communities. But if you're currently governed by WUCIOA, you are required to notify your owners of any modification or addition to your rules and regulations. And we would include policies in this, things like a fine and enforcement policy or a collections policy. And you have to send out the proposed change to your ownership, give them 30 days or whatever in which to comment, tell them ahead of time when you're going to be voting on it, and give owners a meaningful opportunity to comment on the proposed change or addition to your rules. And only once you've done that can the board then vote to adopt the new rules or the collection policy or whatever it is. And at that point, once you give notice to your owners, it can become enforceable. So these documents cannot, or should not anyways, contradict what is in your bylaws, and certainly not what is in your declaration. And you can't do things in the rules, certain things in the rules, again, that are not already provided for in the declaration. So if your declaration is silent on the issue of rentals, then you can't, impose a rental cap or rental related restrictions in your rules. If you've adopted some sort of rental amendment that specifically authorizes the board to adopt rules on the administration of the rental cap, then you could have rental cap administration rules that were adopted by the board. But again, the underlying authority for that has to be in the declaration. The whole reason I wanted to go over this is because we have a lot of folks that use the word bylaws when what they're actually referring to is either all of the governing documents for the community or the declaration, which is recorded and which is a different document. And I think terminology matters because each of these documents kind of land somewhere different in terms of the hierarchy and which one controls if there's a contradiction between them. So I just wanted to give some clarification there before we jump into our questions. And I'm going to just take a peek at the chat to see if there are any
Valerie,
questions.
while you're doing that, I'm going to talk a little bit more about articles of incorporation because I think
Please.
for some people, those might be newer. So for non-Ukiah communities, January 1st, 2028, if you are not already incorporated with the Secretary of State for Washington, you have to be incorporated. And so when you incorporate with the Secretary of State, basically now you have to fill out articles of incorporation. For older communities, those articles of incorporation, as Valerie mentioned, may contain information about the governance of the community. For newer communities, I would say probably 15 to 20 years or younger, those articles of incorporation are much more bare bones. There's now a very easy form to fill out. You basically just put who the governors are, and that's about it. You're not required now to include the whole voting process and what it applies to. I'm pretty sure you can, but I don't know why you would. So for anyone who's not incorporated right now, that is a change to keep on the horizon. It's really easy and it's relatively cheap compared to the rest of the stuff that you have to do. But just keep that in mind. They're not complicated. And if they don't have any meat and bones to them, they're just more of a formality.
Thanks, Katie. And I think that was the only sort of related question in the chat. So we're going to leave the rest of the unrelated questions in the chat for later today. And Katie is going to now address something that is changing sooner for all of us, everybody, which is the changes to our meeting statutes that are taking effect on January 1st of 2026.
Yes. So for HOA and Ukiah, HOA Act and Ukiah communities, this is not going to be as much of a shock. There are some practical changes to keep in mind, but there is now an open meeting requirement that will take effect for all communities, whether or not it's in your documents on January 1st, 2026. So like I said, for those Ukiah and the HOA Act, you've already had an open meeting requirement. So to the extent you haven't been having open meetings, this may come as news to you, but you should have been having open meetings. So what those meetings look like may change, but the fact that owners can attend won't be as different. For non-HOA Act and Ukiah communities who don't have an open meeting requirement already in their documents, all meetings must be open. And so what that means is all board meetings and all committee meetings which exercise board authority are open to owners to sit in and perceive the meeting. And also, and I'll get into it, there's an owner forum requirement in the statute that has to take place at the beginning of the meeting. So practically, this means, and also in the statute, it means no more voting exclusively over email and not having meetings. So any association who's been doing a lot of, or boards who have been doing a lot of approval of things over email and maybe meeting once a quarter, we would, one, you can't do anything over email unless it's ministerial. So that's like voting to extend a ballot deadline for an amendment. That's probably ministerial. Voting to sign a contract or contact an attorney, not ministerial. All of those will have to be at an open board meeting where owners can attend. We do get questions about what about advisory committees because they're not exercising board authority. Our position there is the legislature is very clear with what they're trying to do. They are trying to make everything more transparent to have owners there. So while technically you might not have, if you're not exercising board authority, you might not need to have the meeting open to the owners. It's kind of the statute wants everything open. Why not have it open? You don't need to let owners participate. In fact, we could even support not having this owner forum at all because there's no board decision or board action. But you might as well have it open if the trend of the legislature is to make anything more transparent. So probably the biggest change for everyone is the new statutorily required owner comment period. And I'm going to read it directly from the statute so we're all on the same page. So it says, at each board meeting, the board must provide a reasonable opportunity for unit owners to comment regarding matters affecting the community and the association. And then the big change is the board must provide at least 15 minutes at the beginning of the meeting for unit owners to comment about the agenda items before the board votes. The board may place reasonable time restrictions of not less than 90 seconds per owner per unit, except that time per owner per unit may be reduced and allocated equally if more than 10 unit owners wish to comment. So the first part of that, the comment period must be at the beginning of the meeting, and it must be 15 minutes. We have several associations now that do offer an owner comment period, but we see that most associations offer it at the end, after the board's already made the decision. So this change puts it at the beginning, and it kind of makes sense. What's the point of letting owners talk about something the board's already decided on if they may have valuable things for the board to consider that now the board's already voted, so that's kind of a moot point. So this gives the owners an opportunity to feel heard and actually comment before the board makes a decision. Now, this doesn't mean that owners can talk for as long as they want about whatever they want, whenever they want. Like the statute says later, there can be time restrictions. You only have to allow 15 minutes for the owner to talk. If the owners don't show up in those 15 minutes, they're SOL. You can move on. You don't need to wait because people didn't show up. You could decide that if someone had a legitimate reason, like, I don't know, the bridge was up. One of the bridges somewhere was up and they got stuck for half an hour. You could decide that we'll let them talk, but you don't have to. It's that 15-minute window, and otherwise you can move on. There's also the cap of 90 seconds per owner. So this will help with some people who can't, as my family says, they can't land the plane. So they can't get their point across in a timely manner. This will force them to do it, or you can move on. And if you're on Zoom, this means you can mute people. I mean, I would give them a courtesy, hey, you've reached your time, before just shutting them down, but you don't need to listen to nonsense for forever. So this is also, I would say, a positive. This also does not mean that owners can talk or provide opinion before the board votes on the issue if it's outside those 15 minutes. So there's no comment period before each agenda item. It's one block of 15 minutes, and then owners just get to watch or perceive, or however you do your meeting, the rest of the meeting. And so for some associations, this will provide a lot more structure, especially for those owners who feel like they want to participate in every part of the board meeting. This will curb that and should streamline how meetings go. It also means that by moving it to the beginning, it means that at the end you can just end the meeting and go home. You don't need a 30-40 minute owner forum after to satisfy the requirement. So that's, oh, go ahead.
Do you mind if I jump in with one of the questions from the chat?
No, yes, go ahead.
Does the board have to wait for the entire 15 minutes to elapse if no owners have anything to comment on during that time, trying to avoid having people sit in dead air? And I think you and I might have different answers to this, maybe.
I think we do, and I think we've talked about it before. So I'll give mine and then you can
Yeah,
give yours. And
do it.
what I think is that's an open question and you can decide what works best for your association. What I've mentioned to someone in the past is if no one shows up for the first 5 minutes, I think it's appropriate to move into the meeting. But if someone shows up within, like, say, within the first 15 minutes and you've already moved on, I don't think it's a bad idea to then let them speak because it's still within that 15-minute window.
I think we actually have the same opinion. I
Great.
thought for some reason I thought you were of the opinion that you had to wait the 15 minutes regardless of whether anybody showed up or wanted to comment. So that was my mistake because I don't think that you have to
Right.
wait the entire 15 minutes. But I do think if you start the meeting and somebody rolls in at 7 minutes, then
You
you
do.
should stop the meeting and ask them if they have anything they would like to say before you continue the meeting.
Yeah.
Yeah. There was another question in the chat about we have meetings scheduled in the next few weeks, but we have not provided the 14 days notice. Should we cancel the meetings? And I just put in the chat, but these statutory changes do not take effect until January 1st of 2026. So I don't think that you have to cancel any meetings that you've not noticed properly under these changes now. But I do think that we are encouraging all of our clients to start complying with this stuff now. So go ahead.
That's a great segue to what I was going to talk about next, which was the notice requirements. So as this person pointed out, all meetings, so this means the board meetings or committee meetings exercising board authority, you must provide at least 14 days notice before the meeting. There is an exception if you have standing meetings and you have a schedule of meetings. So say the board meets every 2 weeks on Tuesday at 6 p.m. or the first Tuesday of every month at 8 p.m. You can send that out and then you do not have to send notice every month or 14 days before every meeting. So that's good. That encourages boards to have more structured schedules so that owners can be aware and participate. It also relieves an administrative burden because say you're meeting every 2 weeks because you have a special project going on. Sending a notice 14 days out is basically sending a notice every time you are actually meeting, which is a lot of mail if people haven't opted in to notice electronically. So that also means if you have a standing agenda, so owner forum, call the meeting to call the meeting to order, owner forum, old business, new business, conclusion, adjourn. You can have that standing agenda and you don't need to send it out 14 days in advance. You also do not need to send out all the materials with every agenda. They do have to be available if an owner requests them, but you don't need to send the whole board packet to every owner before every meeting. So that's kind of the notice. Are there any questions before I move on to the next?
Yeah, there were a couple of questions. So when we commented that the changes to the meetings statutes don't take effect until January 1 of next year, the question was, what about the July 27th implementation date? That's for WUCIOA communities only. So if you have WUCIOA communities, they should have been providing unit owners with notice of board meetings already. This is not a change for them. So the change is for non-WUCIOA communities who will be subject to the notice and open board meeting requirements effective January 1 of 2026. If you think you have a WUCIOA community that has scheduled board meetings without providing proper notice to the unit owners, then I think, I don't know if you cancel, if you send out, email blasts and make phone calls or, reasonable efforts to make sure that owners know about the meeting, or if you reschedule because you don't have anything that's, terribly time sensitive on the agenda, because they do have to and have been required to give notice of board meetings in advance even before these changes.
And I will say
But
the notice requirements do not apply to canceling a meeting. So if you have a standing meeting, you can cancel that day, which is a lot easier than having to send out notice 14 days in advance.
There's another question about the notice, which is if we send a schedule for the year with a standing agenda, how will owners know what topics are on the current agenda so they can comment in the open forum?
That's a good question. I think that you can have a standing agenda and then update it closer to the meeting when you know what you want to talk about so that board members can comment. But that's different than creating the whole new meeting notice.
Well, and I think what you do is you have to make the packet that the board uses at the board meeting available to the owners at the meeting as well, with the exception of anything that's privileged or that is not supposed to be disclosed outside of the board. So if you've sent out a standing meeting notice with a standing agenda that says, call meeting to order, establish quorum, approval of old minutes, old business, new business, treasurer's report, whatever the normal sort of general agenda is. On the day of the meeting, you're going to have an actual agenda that's got specific items on it. And you need to make that available to all the owners who attend the board meeting. And that's how they know what's coming up, what's going to be discussed and voted on by the board at that meeting. Also, if an owner contacts you 3 days before a meeting and says, hey, I have this general agenda, but I'm like, what are they actually voting on this week? Then I think you respond with the information requested at that time as well. Katie, did you have anything else to add to that?
I don't. And
Okay.
I think that might be a good ending place given we have other questions. There is a quick question about, can you clarify who's considered a Ukiah community? And I will just answer that really quick. Is any community formed after July,
On or after July 1st?
On or after July 1st, 2018 is a Ukiah community, no matter your layout, no matter anything. And then again, everyone will be a Ukiah community January 1st, 2028.
And there is a small subset of communities that predated WUCIOA that since July 1st, 2018 have adopted an amendment opting into WUCIOA as their governing statute. And I suspect that if your community did that, you would know. So that's who is WUCIOA. Either you were formed since WUCIOA took effect, or you specifically amended your declaration to become a WUCIOA community. Otherwise, you're not a WUCIOA community.
Last thing about the meetings, I think, and then we can go into our questions, is there was a question about what about notice for new members who move in mid-year? Just if you know someone moved in, just send them the schedule. You can include it as like part of the welcome packet or something, but not giving it to them would not, because they moved in the middle of the year, would not be a permissible action. I would like to argue was okay.
Or include it with your resale certificate. If your community just decides we're going to have a standing board meeting schedule and a standing agenda, and we're going to send it out to everybody in the, I don't know, in December every year for the following year, then each year include that agenda and standing board meeting schedule in your resale certificate so that anybody who takes ownership mid-year gets notice of it with the resale packet. Okay, so we have probably could talk the entirety of the hour about this subject, but we do also have some other questions that were submitted. So we're going to go ahead and move on to those. If we have time at the end, we'll try to come back to some of these. But if this discussion has sort of percolated any questions for you that you'd like us to answer, those would be perfect things for you to send to the info@condolaw.net email address for us to include in future weeks' Q&As. And I suspect we're going to be talking about this a lot between now and January 1, 2026, because it does represent a significant sort of operational change for a lot of our communities. So please, if you have any other questions about this, send them into the email and we'll get them in the future.
I will also be talking about it for a good 75 minutes on October 18th. So you can also bring questions to that if you're already going to CA Day.
Yes, another plug. All right. The next topic that we're going to talk about is this. Somebody sent us RCW 24.03A.575, which is from one of the nonprofit corporation statutes. And they are talking about whether a committee of the board can include non-director members who participate in one of two ways, either as non-voting participants when the committee is exercising board authority, or as voting participants on matters that are advisory only. And the question essentially talks about how the nonprofit statute prohibits non-directors from voting on delegated board powers, but appears silent on their ability to vote on advisory matters, and was just asking for some pointers and feedback on this. And I think where we want to start is your focus when looking at anything related to how your board or committees function should be first on your governing statute, not on the nonprofit corporation statute. In other words, when your governing statute actually says something about something, it trumps anything that the nonprofit corporation statute might say about that same thing. And the nonprofit corporation statutes are really intended for our purposes in community associations to fill in any blanks that are left by our common interest statutes. So if your governing statute talks about committees that exercise the authority of the board, and also advisory committees and who can be members on which and who has the authority to vote on those things, that's where you look. You only look to the nonprofit statute if the governing statute for your community is silent. So as to the actual substance of the question, if any decisions are being made by the committee and they are exercising the authority of the board, then only the board members on the committee can participate in that vote. There can be other non-voting members on the committee who provide insight and guidance, so they can be involved in like the discussion part. They just can't participate in the actual vote. If the committee is voting on something that is advisory only, like making a recommendation to the board about an architectural request, or maybe it's a hearing committee and they're making a recommendation to the board on whether a violation occurred and whether a fine should be assessed, then all of the committee members, including non-board members, can vote on that because they are not exercising the authority of the board. They're just making a recommendation to the board. So I think that answers the question, but the biggest thing I want to say too is that anytime you find yourself struggling with questions like this, always look first to your governing common interest statute and only look to the nonprofit statute if you can't find what you're looking for in your governing statute. Katie, did you have anything you wanted to add to that?
No, I think you covered it.
Okay.
So our next question is, can a board reverse the decision of an architectural review committee, ARC, from a prior board after the project has been completed? So we did answer a very similar question to this a few weeks ago. I believe it was the 16th of July. And that video recording is up on YouTube. So for a more detailed answer, just go back and look at that. But the short answer is probably not, but it depends what it is. If it's prohibited by the governing documents, but a prior board approved it, our answer may be different, but we would need to know what the modification was, what the documents say, everything like that. If the approval was conditional and a condition was not met, that may also impact a board's ability to overrule a prior board or change the decision. But this question requires a lot of information that we don't have and would require legal advice. But again, probably not. New boards can't just go in and undo what old boards did that's been approved for a valid reason. Generally, if an owner acted in good faith with approval of the board and constructed what they proposed to construct, we would find it difficult to support that the board could change their mind. Valerie, anything to add?
Yeah, I mean, I think there's so many factors we would need to know to answer this question, which is part of why the answer is that we can't answer this. I mean, how much time has passed? What is the thing that was approved? How much did it cost the owner to put it up? Because courts hate what they call waste. In other words, if they constructed a 3-story house after receiving approval from the architectural review committee, they're not going to make them tear down a $500,000 or $1 million house unless there are real serious issues with the approval process. So there's just too many factors for us to be able to answer this kind of question in a Q&A forum. Our next question is this. So for some background, we have 80 members in our community of lots, some with houses on them near the ocean. We tried to get an amendment passed to change our bylaws to be congruent with WUCIOA's budget ratification section. We only received 30 ballots out of 80 possible, which was not enough for approval. We have no expectation that our members will ratify a declaration amendment to opt in to WUCIOA. So the question is, can the Board of Trustees, without a vote of the members, amend or restate our bylaws with a declaration to opt into WUCIOA? And if not, what can be done to comply? So I'm going to point everybody back to the primer that I did at the beginning about governing document terminology, because it seems like maybe there's some confusion here and you're using bylaws and declaration maybe interchangeably. But I would like to start by saying that you are subject to and must follow the statute regardless of whether you are able to amend your documents. So since July 1st of 2018, every community association in Washington has been required to ratify a budget in a manner that is consistent with RCW 6490-525. And it doesn't matter if they've been able to amend their governing documents to make that clear. You're still bound by that statute. It is true that after January 1st of 2028, the board might have the authority to do this without a vote of the ownership. And why I'm saying might is because the ability for the board to amend documents to remove provisions that are inconsistent with WUCIOA is a really specific one. And I don't want to confuse anybody by suggesting that once WUCIOA for all takes effect, the board can just adopt a whole restatement without a vote of the ownership. That is not going to be true. So with the understanding that the Declaration of Covenants, Conditions, and Restrictions is the recorded document, and the bylaws is probably procedural only if your documents are written correctly. What you're really talking about is trying to amend your declaration, adopt an amendment to the declaration in order to either just be consistent with the budget ratification process or to adopt WUCIOA as a whole. And on the latter point, I would like to point out that RCW 6490-370, which is a provision within WUCIOA, allows non-WUCIOA communities to adopt WUCIOA as the governing statute for that community if owners with 30% of the voting power in the association participate in the process, and if 67% of those approve the amendment. So if all you want to do is adopt WUCIOA as your governing statute, as long as you get a minimum of 30% of the voting power in your community to participate in the vote, and as long as 67% of the people who do vote are in favor of it, you can adopt an amendment that says WUCIOA is your governing statute. All of that being said, again, you don't need to amend anything. You're still subject to that statute. The same thing will be true in 2028 when WUCIOA for all takes effect. And if you are unable to restate or redo your documents between now and then, you will still be subject to WUCIOA effective January 1 of 2028. And any inconsistent provisions within your governing documents will just be unenforceable. So I'm not sure if that really answers your question. I think that it does. And we expanded upon it a little bit more to make sure that you understand you can adopt WUCIOA with a much lower voting threshold than what's required in most existing governing documents. But also, I think the most important takeaway, in my opinion, is even if you can't amend your documents, you're still subject to the statute. I hope that covers everything. But Katie, if you have anything to add, please feel free.
No, I think you covered it. So our next question is, and this is our second to last question. So to the extent you have questions, start putting them in the chat, because I think we'll have time. What are the statutes regarding an HOAs or condominium owners association charging a fee to track rentals to those owners within a community? Or is it totally related to what's in the governing documents? As an outset, I would say not totally, but it's mostly tied to what's in the documents. As with most fees, if you don't have a tie in the declaration to assess that fee, you probably can't assess it. There may be a combination of statutes and governing documents to support the charge. There's nothing in any of the statutes that are specific for charging a fee for rentals. RCW 6490-640 subsection E requires any fees payable to the association, which may include rental fees, must be included in the resale certificate. And RCW 6490-4051C allows the board to impose assessments for common expenses and specially allocated expenses on unit owners as provided in other statutes. So if the governing documents allow for specific costs incurred by or exclusively for an owner, those can be assessed to them. Sometimes documents contain more specific language about units benefited, where if a owner is benefiting from a service provided, those can be assessed back to the owner. Fees charged related to rental units by the association may be different than fees charged to owners by a management company, and it depends on whether or not the management company is providing a service. For example, management companies often charge for resale certificates and financial disclosures for mortgages, and those are billed to the requesting owner, not the association. But if the association wants to pass off a charge that the management company is charging the association to a specific owner, that needs to be supported in the governing documents. Anything to add, Valerie?
Yeah, the one other thing I would add is any fees that an association charges to its owners have to be reasonable. And they have to, and the way courts assess whether a fee like this might be reasonable is asking the question of whether the charge is related to actual costs incurred by the association in connection with the event that triggers the charge. So I think part of what we look at in determining whether something like this is collectible is also the amount of the charge. So I just had one recently where a client had adopted a rental amendment that specifically authorized the board to set a fee, an annual fee for owners who rented their unit in connection with the just sort of paperwork involved on the management company side and tracking who was in the unit. But the fee was only $150 a year. That was a lot easier to support, especially with the underlying authority in that amendment, than a fee of, $500 or $250 every time occupancy changes, when all you're doing is, typing in an update in your management software. So I think the amount of the fee also matters, and the costs that an association incurs in connection with the fee is part of how a court determines whether the fee is reasonable. Our next question is this. We are a self-managed HOA, but it has become increasingly difficult to manage with all the new laws and lack of continuity with volunteers in the HOA. So we want to move towards a management company. Who has the authority to make that decision? Is it the board? Everyone in the membership has to make that vote. Dues are going to increase because of this, so we are getting a lot of questions and some resistance, and we want to make sure that we're doing this right. The short answer to your question is that this is generally a decision that the board has the authority to make on its own without a vote of the ownership. It is possible that there could be something different within your governing documents, but I think the likelihood of that is rare. We have seen some documents where owner or mortgagee approval is required, but usually that's to terminate professional management, not to hire professional management. And let me be clearer in my language. Usually that is when a community that is professionally managed is choosing to go self-managed. So sometimes I've seen language where it says, in order to terminate professional management and move to being a self-managed community, you might have to take a vote of the ownership to get approval of that. I have not seen a document where hiring a management company on its own is a decision that requires the approval of your owners. If you want to be sure, have your attorney review your declaration really quickly and tell you if there's any limitation there. But if there's no limitation, if it's silent, the board gets to do this without a vote of the owners. If it's going to cost more, which it will, of course, you need to collect more money from your owners, which means your assessments are going to increase. And so you're going to have to ratify a budget that accounts for those increased costs. Your owners sort of have the indirect ability to control this decision because they could reject a budget if they really feel strongly enough about not wanting to pay the increased cost of professional management. Do keep in mind that your budget ratification process has to follow the process that's laid out in RCW 649525. The budget does not have to be affirmatively approved by a majority of your owners. It just has to survive the ratification process. And the only way the owners can reject the budget is if more than 50% of the voting power in your community rejects it, with the one caveat, which is your documents could require a higher percentage to reject it. We just ran into this recently where a client had in the declaration, or maybe an amendment, I don't remember, it was written in that in order to reject a budget, that community had to get 67% of the voting power in the community to reject it.
We
Katie, I
have
can
another
tell
one
you have something to add.
we have another one that's 90% required to reject it, which is
Oh,
crazy. But just
wild.
look in your documents if you're
Interesting.
concerned.
Okay. Well, we do have some questions from the chat, but I'm going to make a really quick detour and talk again about something that I just talked about 2 weeks ago. But I think this is the kind of thing where I'm just going to start talking about it every month until we start to see some changes. And this is about the due process requirement when fining owners for non-compliance with your documents. So those of you that have been here a long time, you can tune me out for the next 3 minutes, maybe. I'm not going to make this a long one because you've heard me say this many times. But the number of violation notices that I get still when I'm evaluating a collection file that's coming into the office, where there is a failure to give appropriate due process, is it's significant. And what I mean by that is all of the governing statutes for common interest communities in Washington, and this is not a new requirement, folks, this has been around for a real long time, say that an association has the authority to fine a unit owner for noncompliance, but only if certain criteria are met. The board has to have adopted a schedule of fines and published it to the unit owners. And the unit owner must be given the right to request a hearing before the fine is assessed. So in terms of timing, if a fine being assessed is sort of the event that we're talking about, due process has to happen before the fine is assessed. If we're talking about the right to request a hearing after the fine is assessed, that's an appeal, and it does not comply with the statutory requirement to give due process. So when I receive a violation notice that says something like this, you have a bunch of junk on your balcony, this is the rule number that you're violating, you are being assessed a fine of $50, you have the right to request a hearing. If you want to do that, let me know. That's not due process because you're fining them and then telling them they have the right to request a hearing. What due process looks like is this. You have a bunch of junk on your balcony. Here's the rule provision that you're violating. This violation carries a fine of $50, which, if assessed, will appear on your account, in 2 weeks. You have the right to request a hearing before this fine is assessed. To request a hearing, submit your request in writing to this email address within, give them a reasonable amount of time. Minimum of 10 days, I think, if you're mailing the notice, just because mail takes so long these days. I would say 2 weeks would be better. But, please submit your hearing request in writing to this email address within 2 weeks. If you do not request a hearing, this fine may be assessed on and put it on the date after the deadline for them to request the hearing. That's due process. So you can tell them what the violation is. You can tell them what the fine is going to be if they don't request a hearing. Then you tell them they have the right to request a hearing, but the fine cannot appear on their ledger on the same day that you send the violation notice. And one of the most common comments that we receive back from, in particular, management companies when we talk about this is, that's really hard to do with our management software, because management software is right, like they're set up with triggering events and then things that happen in response to the trigger. And so I think it seems to me, what my understanding is that when a violation notice is issued, that often triggers a fine being assessed to the ledger. sadly, there's no exception in the statute for incompatible software, or that's hard. And I'm not saying that managers are saying this to me, because y'all are not, but like that's hard. And we've had clients before where I've had a manager contact me and say, my board does not want to give hearings. Can they still find the unit owners? And they're basically asking me to be, tell the board what the manager has already tried to tell them 27 times, which is, no, you can't not offer a hearing. You have to offer a hearing. It's required by the statute. So this is a statutory requirement. I don't want to, beat a dead horse too much, but I'm gonna keep talking about this until we see some changes in the fine notices that we're getting. Because otherwise what happens is when you send the account to us for collection, we tell you those fines are not enforceable because of a failure to give due process. And that makes our clients mad when they hear that, because, they often want those fines to be enforceable because they're trying to use them as an enforcement mechanism to get the owner to comply with the documents. Katie, did you have something to add?
I'm gonna add one thing, and it may require like managers to update templates for specific associations.
Yeah.
But some associations require that in the notice for an opportunity to be heard, that the date, time, and location of the hearing be provided in the notice.
Yep.
So it's not that they can request a hearing, it's that the hearing will be held in 2 weeks at 6 p.m. It can be over Zoom, that's fine, but the notice has to contain date, time, and place of hearing. And if it doesn't, the notice is faulty and would not comply with the governing documents.
So I do want to clarify that is not true across the board. It's just some communities have really wonky, really specific compliance procedures. And that is one of the challenges, I think, because I understand that from a management perspective, for example, uniformity would be so nice. Because if you could have one approach to collections or one approach to violation notices that would work for all of your clients, it would make mistakes a lot less likely. It would make compliance a lot easier. The unfortunate reality is that so many quirks exist in various governing documents that just, I think it's functionally impossible. Or it just results in certain communities being unable to enforce their fines because the process doesn't comply with their documents. So I think we can go ahead and move on. I'm going to scroll back to the first question that was submitted in the chat, which was way back in the beginning. Any suggestions for dealing with residents who ignore recycling and composting guidelines provided by the city? This morning, we found a load of sheetrock in the compost bins. The views of these bins is limited, so it's not usually possible to determine who did it. And even if we do identify the culprit, what is our recourse? Do you want to take a stab at that one, Katie?
I'll start. So I will say any specific answer is going to be dependent on your community and your governing documents, and I'll tell you why. One, we don't know how trash is collected and charged. So we have some associations where each owner pays for their own trash. And we have some associations where it's a common expense, it's part of the dues, and any increased charges for too many yard waste bins or more excess garbage than what the garbage company is expecting, or violations like this where you're not sorting properly. Sometimes those are charged to individual owners. It doesn't matter because the garbage company knows whose bins are whose. I didn't think they did, but I got charged for more garbage because I put it out and I didn't even tell them. So to the extent that the owner is responsible for the cost, that's great. You don't need to care. But if it's an association expense and the association is being hit with a fee or a fine, I don't know if your municipality has fines for putting sheetrock in compost. Some might. That is a different question. And depending on your documents and your rules, may be passed on to the owner. But again, we don't know that without looking at what your documents are or your municipality. If you have rules about garbage, because we have several clients where they say you have to break down boxes, everything must be in the proper bin, blah, 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 blah. You can find violations for violating that. You just need to conduct an investigation based on objective information and adequate inquiry, and then offer a hearing. And if the owner says, I didn't put the sheetrock in the compost, that's something to take into account on whether or not you assess the fine after the violation. Anything to add, Valerie?
Yeah, I mean, one really easy way to make it easier to determine whether somebody did a certain thing is you could just put a security camera up there. You can get super cheap cameras from Costco that connect to an app on your phone and that only record like a 15-second snippet when there is, when it's motion activated. So that's one thing that you could consider depending on how significant a problem this is in your community. Next question from the chat is this. If an owner wishes to audio record the proceedings at a violation hearing, do you know how other associations may handle such a request? Do you want to run with this one?
I can start. So, and I'm going to equate a violation hearing to a board meeting because I just think that's easier. Basically, you can't do anything. Owners, there's an expectation of privacy, not at meetings, but if there is an expectation of privacy, like you're in your completely fenced backyard, having a hushed tone conversation, or you're inside your house, that's when consent for audio recordings comes into play. If I were talking to Valerie on the phone, one-on-one, there's an expectation of privacy. In hearings that are, or board meetings that are open to everyone, there is no expectation of privacy. Anyone can record anything they want to, and they don't even have to tell you. If you don't want to be recorded and someone is recording you, you can always stop participating. But that's your own choice. It is not a you can't record sort of thing.
I do not have anything to add to that. So I'm going to jump to our next question. Is it legal or advisable to have a juvenile curfew in the rules and regs? Curfew covers common areas, including private roadways. I'm going to run with this one.
Oh, I was so excited for this one.
Absolutely not. Any rules that target people based on age run the risk of violating the Fair Housing Act. You cannot discriminate against people based upon their age. So if you're going to have a curfew that says nobody can be playing on the basketball court after 10 p.m., that's fine. But you can't have a rule that says no kids playing on the basketball court after 10 p.m. You also shouldn't have a rule that says no kids in the pool after 7 p.m. or whatever. You could have quiet hours at the pool. You could have, I don't know. There are ways that you can do this that target and regulate behavior as opposed to targeting and regulating people of a certain age. And you want to be really careful anytime you're changing your rules at all, you should have your association attorney review them. But in particular, if you're considering anything that sort of flirts with the edges of anything that I just talked about, you should absolutely have your attorney review them before you implement them, because it's a lot easier to avoid a discrimination claim in advance by being proactive and understanding what you can and can't do than it is to deal with a discrimination claim once one is filed against your community. Katie, did you have anything you wanted to add to that one?
The only thing I'll add is Ken and Jennifer did talk about pools and restrictions on age last week. So if we found the recording, then
did not find the recording yet, but we're working on it.
But we check our YouTube channel because if you want more information on that, because we did actually cover it last week with more specifics about pool and adult swim and all that.
Great. Well, that takes us up to 10:59. So I think that means we're out of time. Thank you all for joining us today. We will not be here next week, so please don't forget that and show up. You'll be very lonely if you do, but we will see you back here in 2 weeks. Bye, everybody.